Good evening. It is Tuesday, May 16th, 2023. The time is 5:30, and we're here to call our regular Urbana Human Relations Commission's meeting to order. Tom, may we have a roll call, please?
Asako Kanazi-Leggett.
Here.
Peter Resnick.
Here.
Greg Schroeder.
Here.
Julie Robinson-Schaefer.
Here.
Stacy Burnett.
Here. All right, we have. Thank you. We have a quorum. Moving on to approval of the agenda. May I have a motion for approval?
I will move to approve.
All right, may I have a second?
I'll second.
All right, we have a motion by Julie, second by Asako. Any amendments, changes to the agenda? Okay, all in favor?
Aye.
Opposed? Okay, moving on to the approval of April 18th, 2023 minutes. May I have a motion for approval?
So moved. Second.
All right, motion by Greg, second by Pete. Any revisions? All right, all in favor?
Aye.
Aye.
Opposed? Okay, that motion is granted. Moving on to public participation. Have one out in the audience. Okay, thank you for joining us. Okay, moving on to unfinished business. Public hearing case number UC 2022 PH1 update.
You want me to go ahead and just, okay. I'll take the floor. All right, as you know, I'm David Weston, the city attorney, and so I've been involved with this particular case that was submitted to the commission for public hearing. The update, as you're aware, is that there was an agreement reached between the underlying parties of the case. When that was shared with the hearing officer, she had issued an order just indicating a recommendation to the commission for dismissal of the two kind of parts to this. One is the case number that was designated for the public hearing part of it, but there's also the underlying original complaint case number that was assigned to it when it got filed. And so with the agreement, and I'll kind of step into and again open up for discussion and questions, I think, because I think there's probably going to be a lot, is the agreement then ultimately was to settle all of that. Because there were two case numbers designated for this particular matter, it was the idea of encompassing all of that together with regard to the underlying resolution of the case. Secondarily, if you're familiar, there was some other filings in circuit court relative to these particular parties, and the agreement reached was kind of a global agreement to resolve all of those cases in their entirety. For our purpose, and again, I think from the recommendation from the hearing officer, it literally was just dealing with these particular matters before the commission. And so that was her recommendation. And so in the ordinance, and I apologize, early on there was a situation that had come up and the issue became the idea of confidentiality. And as I recall, the concept is that the gist of complaints are kept confidential until they actually reach a hearing. But with respect to this, and I appreciate Commissioner Resnick pointing it out to you to make me go back and reread the ordinance to recall this, is that a conciliation agreement, the terms of a conciliation agreement are outside the scope of that kind of confidentiality as well. And then it tailed into this particular section, the ordinance that describes the idea that if the parties agree to a conciliation agreement, those terms are then put into the order of the commission that's issued relative to resolving, the case. I think there's been some discussions, I think at least through emails, about the nature of this particular section relative to the idea of trying to conclude the case. And so again, been digesting that and trying to accomplish, I think, what the intent of the ordinance is relative to the draft submitted to the commission for review and potential vote and signature on that. But certainly if you want me to kind of line it out in deeper form, I can do that, unless you'd prefer to kind of ask some questions first and just have kind of a general discussion about, the nature of how this has kind of progressed up through to date.
I mean, I'm happy to bring up the one issue in particular that
Okay.
I've had and had discussed with
Okay.
Dave. And
Go ahead.
so, the current order as stated is not acceptable to me as far as the terms of the agreement, because I don't believe all of the terms have been laid out. And in particular, term 2 is we acknowledge that there is an ordinance and we agree that we will follow it, which doesn't seem like much of a term of an agreement. They had to do that whether they had the agreement or not. And when we discussed this, you would, in email, you had mentioned, well, there are other things in their agreement that they came to together, like releases, which I presume is release of liability for certain things. But as far as what the commission is required to enforce as per 1283, we're going to want to know that they've actually satisfied all of the terms of their agreement, which would include, I presume, things like have they, continued to comply? Have they made assurances that they're going to not advertise? Have they, for instance, done things that we wouldn't agree to, like have they required the person never to mention other violations of the ordinance that the parties have, that the respondent has engaged in? This would be really problematic for the commission. One of the purposes of the way the ordinance is structured is once you've got a finding a probable cause, which is unlike a civil case, it's more like a criminal case, then you lose some of the ability to just negotiate this. And it would be repugnant if, once there's a finding of probable cause, if a party wants to do nefarious things and get the other party to agree to them before coming to hearing, they should wait until the hearing is scheduled and then come to those horrible things, because then the agreement will be confidential. That can't be the intent of the ordinance. So I would say that we are required by 1283 to see the entire content of their agreement and to agree to that and to investigate it within 1 year and make sure they are complying with all of the terms of that agreement. So I will vote against this unless we see the entire agreement as part of our order, which is required by the ordinance. So if you have something that would mitigate against that, please let us know, but I don't see any way around the ordinance on this point.
And I'm not suggesting that that we've been trying to get around this particular provision. I myself, as I shared, I know you disagree with me on the idea, is that this section I think needs some help, and there's a lot of other areas in the ordinance I believe need some help, just in terms of the overall structure and process in place that in an administrative setting I think should be structured differently than the way they are, but that's a topic for another day. And with respect to the idea of trying to convince you that what the draft is sufficient for the commission's purposes, I'm not going to sit here and suggest to you that I'm going to be able to do that based on your thoughts. I would suggest that some of the comments that you've made about the idea of what should or shouldn't be as a part of this particular order are ultimately outside the scope of the particular case in question. I don't think there was allegations that they were advertising that they didn't take Section 8 vouchers to say that part of the order needs to be is you need to do this or that relative to the idea of advertising. And then some of the other pieces in terms of enforcement, which is the way I thought about it. Again, understanding that the concept behind this is that there may be ongoing review, I guess, or information necessary relative to the idea of are they meeting the obligations under this, is just that. So what's in the draft are those terms, which ultimately would maybe be within in my view, within the purview of the commission to determine whether or not there's compliance with them. The releases, I don't see that as a term that would be monitored by the commission to see if how they're accomplishing that. I think that's just a standard in terms of a settlement agreement. In terms of the idea of acknowledging the ordinance and complying with it, and again, I'll just suggest to you, is my experience with the idea of these when the settlement agreement is reached prior to actually going through the hearing and have a judgment entered, is it comes with the idea of that, they're not going to admit that they violated the ordinance because that hasn't been proven. There's not been a full hearing to say we've proven that, at this stage. And that's kind of their position in terms of trying to settle this at a stage where, I guess, in a sense, make the complainant whole, which I, again, have suggested that they've done that. But that's usually a piece of it. And if the suggestion is going to be is that they can't negotiate that point, then there will never, to me, there will never be a possibility of the parties. If they don't reach a conciliation agreement prior to going to hearing, then the thing that I'm thinking right now is that there would never be an agreement reached in the interim period up to the actual hearing. The parties would be forced to actually go through the hearing process, at that point. Because generally speaking, and I'm not saying that that's a given, I just have seen that these kinds of agreements will come with. I'm not going to admit that I did anything wrong, but I'm going to settle it in this fashion if it's agreeable to the other side. And if that's the result of it, then that's kind of how that lines itself out.
I guess I don't know what the agreement says, and that's part of the problem. I don't necessarily think that a conciliation agreement that this commission would approve needs to say we admit guilt. That doesn't seem required. My suggestion was I want to see what they're agreeing to and make sure that we think those terms are things that we can investigate as being met, that we don't believe there's any nefarious behavior going on, that there's, some sort of other payment or other agreement that are not part of the terms. Again, I understand that you have reviewed it and you feel that these are the terms that are appropriate, but that doesn't meet our responsibility. I think we need to be able to review that unless what you're telling me is there's things in that agreement they don't want public, which makes me all the more concerned about what those things are. I don't see a way around that.
Yeah, I'm not suggesting there's stuff in there that, shouldn't be necessarily related to the commission. I'm just, and again, I get it. I mean, it's a little bit of a trust issue, I think, on the idea of I'm telling you those are the actual terms of it that are pretty much within the purview of the commission to oversee as whether or not they comply with it versus actually seeing the agreement in its entirety to confirm, okay, this is what exists in the agreement and is subject to our purview. Certainly understand that, and we can digest that internally if we need to contemplate this a lot further before reaching the ultimate point on that. That's up to the commission to do that. At this point, for I think staff to digest the idea, the perspective, and again, I'm not trying to be in conflict. I understand what you're saying. I just want to end up at a point where we all are kind of on the same page in terms of the idea of what the ordinance contemplates. Because that's honestly a discussion with staff was, it doesn't suggest that the agreement's attached to the order. It just says the order has to have the terms in it, which is how we ended up preparing the draft, was with those particular terms.
Do you have a legal definition of terms and what that would include and what that wouldn't? Because again, exposing us to the agreement, if you can then say to us, look, these are terms, these are not terms, and therefore these are the things you should put in the order, these are things you should not, that seems reasonable. And because if they're not in the order, then only the terms need to be made public. But your assurance that these are the terms, and again, I'll go to term 2, that if that's a term of the agreement, that's an odd term of an agreement.
Yeah, I understand that, and I respect the idea of the commentary, but again, that was built around the idea is that these kinds of settlements prior to an actual judgment being entered are ultimately indicated by, we're not admitting we did anything wrong, but we're willing to settle it at this point under these kinds of under this particular circumstance.
And are those is that the exact wording of the term in the agreement?
I have to go back and look. I can't remember how we ended up saying it versus what's in the agreement.
May I ask a general question while you're working on that one? Yes, I know when we first received the notice of order for dismissal, my question was, can we see the settlement as well? Yes, my concern and I guess the question of what our extended period purview is, if we see the same company entering settlement after settlement, while that does not admit guilt, does the commission have any power at some point to step in and say, it's time to stop making settlements, we need to do something else?
We don't, but that's part of the reason that the settlement agreements are supposed to be public, right? If there's this public appearance that they're settling and settling and settling, and they keep coming to us in their settlement agreements because they keep getting complaints and they keep getting found probable cause, then, for instance, the commission might recommend that there be an investigation of one of the general cases, right, without a specific complaint, which we're allowed to do. It might be the case that the office might want to do an investigation on its own behalf, which is allowed in the ordinance. We can't find against them simply for making lots of settlements, but we've got levers to pull. So, you know, I think the ordinance is pretty clear about what our responsibilities are in terms of reviewing the terms of the agreement and approving the terms of the agreement. And I think general, you know, statements of what those terms are, I think is the wrong way to go with this. So the question was, are the terms as you've stated in the order, the text taken from the agreement?
Not verbatim, no. What it says is, as further consideration for the parties executing this agreement, Ramshaw and Veritas agree that they shall not discriminate against any person because of said person being a member of a protected class, including but not limited to source of income, in connection with the prospective rental of a residential apartment unit.
And no definition in there of what source of income means to them, I presume.
Not on here, no.
And
but-
not a reference to the ordinance in that.
Yes, I guess I'll say it that way. My understanding, and again, the way I position this is that because this is under the city's ordinances, that's the operation of this, is that they need to comply with the ordinance.
I'm inclined not to make a motion to approve the order today as it stands, and if others do, I'll vote against.
Do we have any others who are in agreement with Pete to make a motion? To agree? To not make a?
Is there anyone
Motion.
who wants to make?
Wants to make a motion, or?
Guess I might offer ultimately, maybe what might be more beneficial is to, and this is just me, the commission's free to do this as they see fit, is to gauge the consensus of the commission relative to Commissioner Resnick's kind of commentary about the idea of the way the order is currently structured and what the commission would desire to see if there's not a consensus of that the current draft is really the way it should be lined out. And if that's the case, that gives us then the ability to go back and you know, retool and you know, get to the ultimate point, I think, from the commission's perspective about the way this needs to look.
So a follow-up question, because he gave us the language from the agreement. If that were to be inserted in the order of dismissal, I know it doesn't define source of income, but would that then alleviate some of the concerns?
It absolutely would, you know, and this is why, for me, I would say the commission should review the entire agreement between the parties. We should then consult with staff to make sure that all of the terms verbatim appear in our order. If there's things in the agreement that are not what we would consider terms, with consultation of the city attorney, I mean, he is our legal counsel here, that we would not need to include those if they would be confusing, if they would be problematic, and if they do not need to be revealed to the public. That seems perfectly reasonable. But I think we should have the agreement as stated in front of us to make sure that we're not missing anything, so that we know a year from now when we have to do our investigation that we understand what we're investigating and whether they've met those burdens.
And I think that makes some sense, yeah, so.
And that everyone is clear on the definitions of what's implied. Okay.
Because I think that kind of discussion, I think, lends itself to, I think, our kind of emails in terms of, and the question about what's the definition of term. I think ultimately, as Commissioner Resnick has pointed out, I think to a degree it does kind of fall within what the commission should, or believes, I guess, or understands that to mean. Because I think going forward, part of this, I think, is the idea is, all right, going forward, if there's going to be others of these things, it's going to give, I think, us staff the ability to understand what the commission's perspective about how this needs to occur, the mechanics of it, so that we're not necessarily kind of, again, wrangling every time we kind of run into this particular situation, so.
And I'm sorry, go ahead, Carla.
Oh, and I was just going to add with the definitions is to define conciliation versus dismissal, because those are two different things, and we need to know which is which.
And I'll just kind of follow up on that, because I know I think Commissioner Isaac pointed this out to you again. I think in his email to me, and I absolutely agree and acknowledge, we're in an administrative setting, not in circuit court. And I did not want to speak for the other attorneys, including, Attorney Nally, who's the hearing officer on this thing, in terms of our thought process about this, because I think we're all driven generally to circuit court proceedings, which is just the idea is that, these things come just with that term used as far as dismissal goes versus the idea of issuing an order that includes the terms on that. So I don't know if there's any potential dispute on the idea of that concept as, okay, we're not in circuit court, so the idea of dismissal ultimately is maybe not necessarily the right term to be using for the mechanics of this particular process. I will just share with you, I think that's what drove the idea behind Hearing Officer Nally's recommendation, was because I think it's driven to that concept of, this is what we're already in the point of having kind of, in a sense, the complaint for hearing. If we relate that to a complaint filed in circuit court, right? The complaint for hearing before you, similar to a complaint filed in circuit court, once you're after that's happened, and you've reached agreement to the idea of closing the case out in circuit court, what happens is the judge just signs a dismissal order, and that's just it. That ends it. On that versus maybe here being an administrative setting is the mechanics being a little bit different.
And just a quick question. In a criminal case, if a case is dismissed because the parties have come to some sort of sentencing agreement or something like that, I mean, in those cases, it's the case that the judge has to participate in that in some way, correct?
What I'll share, I guess, and I appreciate maybe that question because I think it may be worth a commentary on that, is I get we're talking about a violation of a city ordinance, but in that arena, it's actually a civil case, not a criminal one. And so I get the concept of what you're talking about as far as in criminal court, there may be a possibility where a judge may decide, you know what, I'm not going to agree. I'm not going to sign off on that agreement, that plea agreement that you've just given me because I don't think it makes any sense relative to, maybe the underlying circumstances. These are civil in nature because you can't go to jail for anything like this. And ultimately, they're obviously, this is a broader scope perspective from what I generally do for ordinance violation cases because there's, in a sense, I guess I will say that I think 100% of the time, you're going to have a quote-unquote kind of victim or underlying complainant that needs to be accounted for in these situations where a lot of others don't. And so, there's just fines only in those particular proceedings. But even though that's kind of a penalty for a violation, the structure of these proceedings are all civil in nature. That's where, again, I've not related to a criminal case because my mechanism is always ordinance violation cases are civil in nature. It's all in the civil kind of arena.
And I guess the difference for me is it's an odd duck. It may in fact be unique in that it's not that the complainant hires their own attorney. The city is bringing the charge against the respondent.
Right.
And once the hearing's done, if we find the respondent has violated, we can fine them, but we can also order back pay, we can order reinstatement, we can do all sorts of things. And so it is civil, at least in some ways, but very different than most proceedings.
Yes, agreed.
So, anyone else have anything? Okay, so, should we?
I guess unless someone wants to make a motion in favor of the current order,
Okay.
I propose that we see the agreement and then have discussion. And I don't know how exactly the mechanism to do that will be, but, yeah.
Okay. Is
something
there anyone
along those
who would
lines.
like to make a motion to approve? Any opposed?
And I appreciate Commissioner Resnick's thought about the idea of, I think going forward, how to kind of relay this. And the only reason I say that is I had already shared with staff that, for the commission's June meeting, I will be out of town and not here. And so, unfortunately, that may kind of push it, beyond that point. I think a lot can be maybe done, by email. I'm not concerned about that. Only as a caveat, as I always tell any boards, commissions, or councils is, if it comes out, and I think Carla did this too, and you're probably familiar with it, is don't reply all. Anything that comes out, to the body as a whole, don't do reply all, because then you run afoul of that. But I think even given that kind of framework, hopefully we could accomplish some things, at least by, emails, up until a point maybe we'd be able to have a meeting. And I'm not suggesting to schedule a special meeting unless that's a desire, just to try and get to this sooner than later. But I just wanted to let the commission know what my timing is, trying to kind of get to the point of, in a sense, closing out the case, so.
Thank you.
I will stick around for the next item because I think, Carla didn't share that, maybe I should, but I saw, when I printed off the agenda, I saw the next item too, and I'm like, okay, there might be some more discussion, I think, relative to this concept. I have an idea, I think, from Carla sharing it with me, but I'll let Chair kind of comment about what the next item is, and then we can kind of open that up a little bit for discussion too.
Okay, yes, moving on to item B on our unfinished business, the HREO or designee EEO interim authority update, I'm sorry.
Okay. At our last meeting, you asked if I would go back and have conversations with legal, and I also spoke with the HR person who does the approvals of the payments of the EEO, and checks the EEO certifications prior to payments. And the conclusion was that the Human Rights Commission does not have the authority to give me authority to approve or disprove certifications because of the code, and I believe I'm saying it's in the code, that authority was given to you via, the council and the code, and that you cannot give that to me. That if you wanted to do that, which I think we really need to consider doing, it would have to go to the city council.
Yeah, and just as an add-on, when Carla first approached me and started discussing about this, I think actually from Commissioner Resnick, I was like, oh, sure, certainly, because going into it, I actually kind of assumed it was kind of part of the bylaws about the idea of what the commission's responsibility maybe was relative to these EEO certifications, on the idea of, okay, how do they do? They just go and review it and they'll go ahead and issue that. In that instance, I would have told Carla that I think that's an easy mechanism then, because it's internal with the commission itself. When I went back and further reviewed it, the way the ordinances are structured, it talks about the commission relaying to ultimately the mayor, really, on the certifications. And when I saw it, I'm like, because it's all classified as far as the quote-unquote commission. And my concern is given the dynamic of that, I did not believe that the commission then could delegate that to Carla based on how that seems to have been, structured as far as providing that kind of certification to the mayor for that. I think it's beneficial. I think the way Carla described it, and again, you open it up and you can kind of clue me into anything different, is it certainly makes some sense, I think, because of the nature of what those are about. And again, not trying to get around what ultimately the goal is for those certifications and for the vendors that the city is going into. But I think the concern ultimately was about the idea of timing. If there were periods of time where the commission did not have a quorum to meet and kind of go through that, I don't know how that would impact the idea of getting projects completed or underway because of the waiting for the certifications. And so, I think it definitely warrants some discussion and maybe some thought about how to structure that to maybe provide that ability. But I certainly want to do it in the right way. Ultimately, on the idea is that, because what I shared with Carla was, it makes perfect sense But what I would not want to have happen is for the commission ultimately to face someone, trying to argue over whether it was appropriate. I think if it was a scenario where you went a couple of months without it and Carla goes in and issues the interim certification is have someone start complaining about the idea of allowing a particular vendor to do that when it's an interim certification versus, somebody else who may have not bid on this project or done anything relative to it, but they've already got a certification that covers the time period of that particular work. And so it does, have a little bit of an impact on the operation of the city and how that goes. But
And Dave, you can help me or not, but it did have some implications on contracts. Was that, am I remembering that correctly?
yeah, because part of what ends up happening is, I think, is because the certification is a requirement for the contracts, is if there's not one, then it's a potential concept for terminating or altering the idea of actually being able to enter into the contract in the first place. And so, I think if there was if we put in place the idea of providing, limited authority, and it would be classified specifically that way as far as limited authority, just to ensure that everyone understands this is not the commission putting it all on Carla to go ahead and do all of that, but it's only for a limited kind of circumstance to do that. I think people would understand it, but what I would hate is, again, like I said, somebody to come back and say, well, because it's not a true full certification, is you can't enter into that contract, or that contract has to be terminated because they don't have the actual regular, certification.
So the question I brought up at the meeting last time, my understanding was that our 2-year approval, 1 year with a letter, that's arbitrary and not in the ordinance, that's something we made up to sort of grease the skids, but that.
I think that's right, yeah, because I think the ordinance just talks about that. The commission will issue the certification, but it doesn't detail how
I was
that-
looking for that. Does it
that
even
looks.
say that we issue a certification or that we review every so often? Because the way the rest of it was structured was about if we find that they are not complying with, if they are discriminating, then that becomes a contract violation, which sort of presumes that the contract is already in place.
There's 2 areas of the code that comment about this, and I appreciate it, because it took me a minute. It took me a minute too, ultimately, because I went to one place first, and I think it probably was the section that you're kind of hinting on, where it didn't really comment much about this. But there's another, and I apologize. I'd have to try and pull it up, I guess, quick. But there's a couple of provisions. I first went to look for the commission's area of responsibility itself on the idea of this, but the real kicker is actually, I think, in the other section that talks about in the finance area about purchases, the city's purchases, or the vendor requirement for contracting with the city. It's a completely different area of the code.
Because and I don't know about that part of the code, which is interesting, but I'm wondering if there's some way we can come up with an alternate, because like I said, my belief was I was on the commission when we came up with that sort of strategy of 2-year approvals, 1-year approval, because that was convenient and kept us out of a constant stream of this contract is coming up, review it please now. And so we were kind of leaving ourselves some runway. If there's a way to structure it that is similar but complies with this part that you're talking about in a way that would make the contracts people happy,
Right.
even just thinking of a completely different structure, since the structure we've got now isn't required, it's just what we came up with.
Sure, yeah, I understand. I appreciate the perspective, and I don't want to put a square peg in a round hole, so to speak, although I do try and do that sometimes to try and get to the goal, is try and account for that, because the language, I think, in the other area of the code talks about the commission, I think, certifying to the mayor of their compliance with the EEO requirements. And so, I get it, and I appreciate that thought, because I hadn't thought about it in that way, which is the commission maybe decided, okay, yeah, we've got to do these certifications, but here's how we'll manage it. We'll say, hey, we'll maybe issue 1 year here, but maybe on these circumstances, we'll issue 2 years. So internally, you've made that decision on how to process them to a degree, is if there's a way to kind of meld this together. But it was the language about the commission certifying to the mayor that just caused me some concern about how to reach that.
Right, and, if there's some way to divorce that certification from we got to pay this contract, or we've got to engage in this contract, because if the two aren't inextricably tied, then we might be able to come up with a procedure that satisfies finance and satisfies our requirements to the mayor.
Right. Yep.
So what is our next step to move forward for city council approval?
Yeah, I'm sorry, I did not want to cut you off, Carla, only because I think it's a takeoff of Commissioner Resnick's point. And what I'd like to do is maybe put my thinking cap on a little bit and just see if, even given the wording of that other area of the code, is if there's some wiggle room on the idea of structuring this in a way to kind of meet what we're talking about and not run afoul of how that is kind of designed to work. Before we reach the point of, okay, is there no other possibility other than taking a nice, short, quick, easy amendment to the council on, hey, this is the background, we need to kind of set up this little alternate thing, limited circumstance concept here to allow for, engaging in vendors and contracting, so. So again, I apologize, only because I'm gone in June. That certainly, again, also can be done by emails. I always take work with me, unfortunately, which I know my wife gets on me all the time about. But is I try and stay on top of things enough, even if for some reason maybe it's not ready, or if it is, Carla may be able to kind of present that maybe at the next meeting if she's available to you in terms of maybe what I've shared with her and how to maybe approach this, and at least give you the ideas. Can we structure this in the way we've just talked about, or as our only alternative to go to the council, and then we can kind of talk about that path and what that looks like.
Yeah, because rewriting our procedures, we can just do.
Right.
If we can come up with a way to do that. And if we need to bring something to council, I think it would be good if the commission sort of made a resolution so that we could all collectively recommend to council that we're on board, this works. And
Yeah.
Should we bring this, place this back on the table for June or July meeting? Will we be ready by then? Okay.
At least discussion.
Right, discussion in June, okay. Okay. All right, so we will bring that back to the forefront in June. Thank you so much. I
I'll say
appreciate it.
thank
Thank you.
you're off the hook.
I think I got this next one, Dave.
All right, moving on to new business, which is the EEO workforce statistics, and we have about 10. And 1, 2, 3, 4, 5, 6, approximately 6 new. We have applied pavement technology, corrective asphalt materials, Freehill Asphalt, Renovart Innovations, Complete Asphalt Service, Miller Pipeline, Denler, MMix Group Infrastructure Engineering, and Davis Hoke Mechanical. Would anyone like to make a motion?
Since I'm not prepared to make a motion, I'll just read along.
So last time you provided Carla's recommendations. Is that a standard procedure now, or we just consider those and they don't need to be on over in the meeting?
I like
them.
to be there, but
I'd-
I'm happy to take, I'm sorry. I love staff recommendations just so I can at least quickly scan and go, okay, what do they think we have to look at? But we have always had the tradition of, if we read them over and go, that one should be this instead of that, we're perfectly welcome to switch them on the fly.
No, I appreciate them. I was just wondering, last time felt like the first time that you read the names of the businesses, followed by each of the recommendations, and then someone made a motion for what they recommended, and if there was a discussion of.
That way.
I do.
Would you like me to make that?
Make a motion from the recommendations and then we can discuss.
No.
I'm sorry. Oh, you want yours back? Oh, okay. Okay, there you go.
Passing
All
notes in
right, so-
class.
Prior to you guys looking at that, I do want to just add one more thing to my recommendations. is for the Davis and Hoke. We did ask them for some additional information, and we did get some additional information from them. However, in our assessment, I don't think we got the information that we needed. And so I was going to amend my recommendation to no certification, but that would be, you guys can make any decision you like, but I was going to change it to, excuse me, no certification.
So as in require more, wait for more information.
Thank you. Okay, so for applied pavement, it was recommended for 2 years. Complete asphalt service, 2 years. Corrective asphalt materials, 2 years. Davis Hoke, no certification. Waiting for, we're waiting for more information. Denler, recommendation is 2 years. Free Hill Asphalt, 2 years. Mixed Group, 2 years. Infrastructure Engineering, 2 years. Miller Pipeline, 1 year. And Renovart Innovations, 2 years. I guess there's a recommendation for a letter, or we need a amendment for Miller Pipeline. Letter, yes. Okay, anyone that's open for discussion? Anyone would like to make a motion?
Question. For Miller Pipeline, what is,
You have to-
I have a question.
Anyway,
So-
just wanna make sure.
I know,
For Miller Pipeline, it says commendation and letter, what does that mean?
Is that we could say that they were doing a good job, but we would really like to see them continue and with what they're doing, but just more increase in their efforts.
is this after the one, because they're new, it's listed here as new, so are they new? Okay.
Historically, I believe that the commission would give new applications 2 years, but when we looked at the information, we thought maybe do 1 year, but let them know that they were doing a good job, but we would like to see some improvement in different areas.
And I guess what was the areas of concern? They're in Indianapolis. Mhm. Oh, let me get mine.
I mean, their numbers are not great for Indianapolis. You know, it's good that they have provided appropriate policies and things, but we'd like to see some progress by
I
next
see
year.
it now, yes.
Thank you.
I see
I
it
had
now.
I had to look at, I wanted
just
to look
saw
at
the
the
numbers.
application, because I'm like,
Yes.
I know there was a reason why I said that.
Okay, I see it now. True, okay. All right, anyone that would like to make a motion? Okay,
I will make a motion. Unfortunately, I've put mine in alphabetical order.
that's fine.
We'll hop around.
Okay.
Applied Pavement Technology, 1 year with commendation. That strays from the recommendation. I appreciated all the efforts they're putting in place, but for their EEO update, they're actually making reverse progress. So that's 1 year with commendation. The rest follow Carla's recommendations, so complete asphalt service, 2 years. Corrective asphalt materials, 2 years. Davis Hook Mechanical, no recommendation, await further information. Denler, 2 years. Free Hill Asphalt, 2 years. Mixed Group Incorporated, 2 years. Infrastructure Engineering Incorporated, 2 years. Miller Pipeline, 1 year with commendation. And Renovart Innovation, 2 years.
I'll second.
Okay, we have a motion by Greg, a second by Pete.
And I'll just mention for Davis Hoke, just so there's no confusion, they probably shouldn't be part of the motion. We don't want it to sound like we are telling them that they have violated something yet. We, it's not that we're disapproving, we are just not yet ready to approve, so,
Agreed, and thereby removed from my motion.
excellent.
Okay, all right. All right, do I need to read them again, or are we okay? All right, all in favor?
Aye.
Aye.
Any opposed? All right, that motion carries. And so we'll just have a follow-up with Davis and Hoke on the next meeting. Okay, moving on to number 7, officer report. Carla? I know, right?
I was writing those notes that you just said. Okay. For the month of May, we have 2 formal complaints, but one of them, I just got the signature from the city attorney, and so that one will be closed, and it will be a dismissal for lack of jurisdiction. And we still have one that I'm gathering information for the housing one and its source of income, and we are making progress on that, and I hope to have that one resolved soon, too. We don't have any any informal complaints at this time. The outreach for new members has produced 1 potential new member. This person will go to the City Council next Monday, May 22nd, and upon approval, they will start immediately on the HRC board. Provisional EEO certifications will need to be, we already went through that one. And then a reminder to please volunteer for the City of Urbana booths for Jetty Roads Day, June 24th in King Park. Outreach will be done at this event also. And I also wanted to share that, and I had forgotten about this, but when I grabbed my folder for the HRC, there are 2 additional names that I need to reach out to. So that'll bring us to a total of, I believe, 9 people that I've reached out to. We have 1. I'm hoping that we can get a few more.
All right, sounds good. Oh, I was going to ask for the Jetty Road, it just reminded me a few years ago what we used to do for the Jetty Roads by providing water, or do we have a budget in place for?
If there's something that you would like to do, we can look at that.
Okay.
We'll just use the Office of Human Rights and Equities budget.
Okay. Thank you. Okay, moving on to announcements, we have reports from commissioners, the 1222G complaints coming up in June.
Well, since it's on the agenda that way, I had a question, and I might as well ask it here. So I had one of the 1222G complaints, started the investigation, contacted the person who made the report, and haven't gotten feedback. I got one message, we did a little 1 round trip, and then silence. And so, do we have anything in our procedure about if we sort of run into a roadblock? Should I just write up what I've got and recommend that as the report of the commission, or?
I would say so.
Okay, I'll give it 1 more go, and then I'll call it done and write up what I found out.
Similar in court.
Okay.
No show.
That sounds fine.
Just a reminder to send your report to Stacy, myself, and the mayor.
Right. Does the commission as a whole have to approve each of our reports, or is the procedure that we just submit them?
My understanding was that you submit them, you guys accept them, and then you have a representative attend a
The city
council
council.
meeting and report out, and I would be with that person.
Got it.
And we
Okay.
would make a report to the council.
Okay. Thanks.
So for those that have submitted to the chair, the mayor, and the officer, the next step will be next month's meeting where we then discuss, present our finding. Well, I guess the chair will present.
That is where the procedure gets kind of fuzzy.
Shoot. We might need to clarify.
Yeah, we might need to clarify. My understanding was that you would present your information to the commission at a meeting. And then you guys could vote and say, yes, we can accept this, and we'll move it forward to the, for our presentation for the council.
It would be easier if you could explain, since you did the research.
So we can
And-
anticipate a long
Findings.
meeting next time, is what you're saying.
If we have
Depends on the length of
everyone's-
your summary.
If everyone
then
has something to report.
If you have something to report and you're ready to report, I've been telling people, go ahead and report. And then we'll come
But
up with a,
that's the step after it goes to you, so.
yeah.
Yeah.
And then we can come up with a date where myself and one of the commissioners will go to the council and just report what we've seen. And I'll try to get on their schedule.
Okay, and which is moving to our next scheduled meeting, is set for Tuesday, June 20th at 5:30. Is there any conflicts? Everyone is okay? And then we also have our July meeting scheduled for July 11th at 5:30.
And just a reminder, that's a change to accommodate the commissioners.
All right.
Stand by while I confirm
So-
June 20th.
Okay.
My calendar except the HRC meeting,
Okay.
which is back to 5:30 every time? Yes. Okay.
Okay. All right. If there's nothing else,
I'm gonna jump in. Carla's
Okay.
gonna, she's like, no.
okay.
So my commission expires in June, so I will be stepping down after next month's meeting. I know. It's like- So I'm very happy to hear we have another member potentially joining shortly, so. So, yes, I have enjoyed it, I know.
On that note, I will also be stepping down in August.
You are.
I got a new job and it has a different schedule, so.
Yeah.
Even if I wanted to step down.
Don't even kid about it.
Well, we certainly appreciate your service and the knowledge you've given us during your term, and I'm very sad. Same with you, Asako. Thank you so much. But you said August for you, and,
Next month.
so you're just, okay, you will be at the June.
I will be attending the June meeting.
Okay. Okay.
Being that we are discussing the order of dismissal, does that mean we should not plan on needing two consecutive meetings with the same quorum for a hearing? If we are now having different attendance in June and July, and then, well, you'll be July and August, correct? June and July. July is your last meeting.
Well, depending on what happens in June, I think you're not having the hearing. I think you're having a discussion about whether to have the hearing or not. And then, so I think that rule will apply if it moves forward to a hearing.
I think in this weird circumstance, if somehow we decided we're not going to dismiss the case and we're going to go forward with the hearing, we may have to start some things over if we have a whole new commission. If we actually succeed in getting the agreement in the way that it's appropriate and we do the order of dismissal, I don't think it matters which among us are present. But yeah, if we restart the idea of having this hearing again, we may have to jump through some hoops to make it kosher. Let's hope we don't do that.
Well, the good thing is we haven't started the hearing process.
Well,
of it,
I'm worried about the fact that we had the preliminary hearing already and whether that started certain things from happening. And let's just hope that
But-
this all resolves itself the way we believe it will.
from your lips.
Meeting adjourned.